A crucial issue in employment law is whether you're an employee, a worker, or a self-employed contractor. The answer has a massive impact on your employment rights. On Friday, the Supreme Court, which is the highest court in the UK, gave its decision in the well-known Uber case and ruled that Uber drivers are classified as workers and not self-employed individuals, as Uber had been arguing. I'm joined now by Jason Galbraith-Marten QC, the barrister who successfully represented the lead claimants in the Uber case. Jason, how does the Supreme Court's decision benefit Uber drivers? Good evening.
Evening, Daniel. Nice to talk to you. Thanks for having me on the show. So in a very narrow sense, it benefits those people that were claimants in the case. So my clients, James Farrar, Yassin Aslam. But as you know, and you've just mentioned, Supreme Court being the highest court in the land, it sets a precedent. And that precedent means what the court had to say in that case will be applied in other cases. It will be binding on employment tribunals, so that if any other Uber driver brings a similar claim, working time claim for holiday pay or for national minimum wage, the decision of the Supreme Court will effectively determine the outcome in that employment tribunal case. An interesting question actually is whether Uber will wait to be sued by Uber drivers, or whether it will apply the Supreme Court's decision to its drivers generally. And the indications are at the moment, from what they've said, that they might not apply it automatically, and other Uber drivers may have to think about bringing a claim. But that's not clear yet. That'll play out over the next few weeks. Well,
the official response that I've heard from Uber in their press releases is that the Supreme Court decision only applies to a small number of drivers from 2016. Is that right?
Yeah, well, technically it does, because it's a judgment in the case that was brought by those drivers in 2016. So technically they're right to say that. But I'm very clear, any other Uber driver who brings a claim relying on virtually the same facts will get the same outcome.
So what impact do you think the case has on Uber's business model going forward?
Interesting. Someone pointed out to me that on Friday, when the judgment came out, the share price of Uber fell by a certain percentage, and they'd calculated that it was about $2 billion in terms of its impact. Obviously, if Uber now has to pay more money to its drivers in order to meet minimum wage legislation and to give them the protections that, for example, the working time regs give them, it's going to cost Uber more money. That's either going to eat into its profits, or that cost is going to be passed along to the consumer. Obviously, it sells itself on being a cheap mode of private transport, cheaper than, they say, for example, black cabs. They'll want to keep it that way in order to maintain their market share. They'll need to maintain a price differential, which means, in theory, that will come out of their profits. But we'll see.
Might the position be different, Jason Galbraith-Marten, for drivers who work for multiple gig economy businesses simultaneously? So one day they work for Uber, the next day they work for Deliveroo, the day after that they work for Addison Lee.
So probably not in that exact example, not the day after they might work for Addison Lee. A really interesting question that arose during the course of the case was what happens where someone has multiple apps on, not one day after the other, but at the same time. They're sitting in their cab and they've got the Captain app on and the Addison Lee on, and they've got Uber on, and they accept a ride from whichever company sends them the first trip request. The court didn't have to finally resolve that problem, partly because back in 2016, when this case started, there weren't so many apps around, and neither of my clients did Multiapp, as it's known. They essentially just worked for Uber. Things have moved on, and now, as I understand it, people are able to have more than one app on at the same time. So the Supreme Court hasn't finally resolved that issue. I personally don't think it's a problem. I really don't. I think you can have more than one boss. You can work for LBC at night and be a barrister during the day, Daniel, as you well know. So you can have more than one job, and you can have more than one employer. So why can't drivers be employed by Addison Lee and Uber?
You were the person at the front, Jason, arguing the case before 7 Supreme Court judges, but presumably there was a big team working with you.
It was a huge team. So I absolutely couldn't have done it without junior counsel Sharon O'Meary, who worked very closely with me. Paul Jennings and Rachel Matheson in particular at Bates Wells and Braithwaite were sort of the legal team. I'm not sure if it's widely known. We were all working pro bono. Essentially, that means we were doing it for free. We were doing that because we believed in the principle that we were establishing all the way up from the Employment Tribunal up to the Supreme Court. And of course, it's down to the drivers themselves. People often struggle to bring claims, either because the law's complicated, it's perceived as being very expensive, or they're just very worried about the consequences if they put their head above the parapet, if they're the lead claimant. So to James and Yassine, a big shout to them for having the courage to put themselves forward on behalf of other Uber drivers.
That was Jason Galbraith-Marten QC, the barrister at Cloisters, who represented the drivers in the Uber case.